Good morning, everyone, and I apologize for the delay. Welcome to the Special Joint Committee on Medical Assistance in Dying. I'd like to begin by welcoming members of the committee, witnesses, as well as those watching this meeting on the web.
It's Mark Gardo, and I am the House of Commons Joint Chair of this committee. I am joined this morning by the Honourable Marie-Françoise Mégy, the Senate's Joint Deputy Chair. Today, we are continuing our examination of the statutory review of the provisions of the Criminal Code related to medical assistance in dying and their application. Just a few administrative remarks. I'd like to remind members and witnesses to keep their microphones muted unless recognized by name by one of the joint chairs. A reminder that all comments should also be addressed through the joint chairs. When speaking, please speak slowly and clearly. This is important for the interpreters. Interpretation in this video conference will work like an in-person committee meeting. You have the choice at the bottom of your screen under the globe where it says interpretation of choosing either floor, English, or French. With that, I would like to welcome our witnesses for panel one who are here to discuss advance requests. We have Dr. Alice Maria Chung, who is a clinical associate professor by video conference. Nous avons le Dr. Jude Poirier.
We have Dr. Jude de Poirier, full professor of medicine and psychiatry from the University of McGill, the Center for Studies in the Prevention of Alzheimer's Disease, also by video conference.
And Dr. Ross Upshur, professor at the Dalla Lana School of Public Health and Department of Family and Community Medicine of the University of Toronto, also by video conference. Thank you all for joining us, and we'll begin with opening remarks by Dr. Chung, followed by Dr. Poirier, and followed by Dr. Upshur. Dr. Chung, you have 5 minutes. The floor is yours.
Thank you very much, and good morning from Spain. I'd also like to thank the IT support people for making this. Yes?
I'm sorry, just a moment, please. Oui, Monsieur Thériault.
Oui.
Yes, could you adjust the volume level in the room? Otherwise, I'm going to have to turn the sound up to its full volume levels in the room.
Lower the sound level in the committee room so that Mr. Thériault can hear the translation on his headset.
Yes, Mr. Chair, it's done.
Okay, thank you very much. So Dr. Chung, please resume.
Thank you to the IT support people that have made this less stressful for me. Thank you to the committee for allowing me the opportunity to address my concerns regarding advance directives for MAID in people living with dementia. I'm a geriatric medicine physician who has been looking after frail elderly people since 1989 for over 30 years now. I do home visits 3 half days a week for housebound seniors, as well as seeing elderly patients in hospital and in clinic. I'm also the daughter caregiver for my 97-year-old father and helped him care for my mother, who passed away with severe dementia after living gracefully and with dignity until the age of 96. I'm also involved in the care of a couple of my father's relatives who are also in their late 80s and 90s. I am professionally and personally committed to caring for those living with dementia at all stages, from early to late. I am a firm believer in patient autonomy. If a patient is able to comprehend information on a treatment versus other options and is able to come to a decision and communicate that decision, their wishes should be honored, no matter how frail they may be. If they are capable of decision-making, I will support their decision. They should also, however, be allowed to withdraw consent at any time, especially when the effects may be life-altering. I teach capacity assessments to medical students, residents, and practicing physicians, so they will be able to identify whether a patient is capable of medical decision-making. The issue with advance directives for MAID are severalfold. Firstly, we are not able to predict with accuracy what our own quality of life will be in the future, let alone if we were also living with a chronic medical illness. What right does 60 or 70-year-old you have to judge the quality of life of 80 or 90-year-old you? And patients with chronic illnesses can often adapt to their altered circumstances and develop a new equilibrium, a sense of self, and feel that their quality of life is actually quite good. The medical literature has demonstrated this to be true, and I happen to have seen it in my years of practice as well. Secondly, with end-stage dementia, there would be absolutely no chance to withdraw consent, which is also essential to informed consent. Someone else, a healthcare worker who may not know the patient, or a caregiver would have to decide when it's time for MAID to proceed. Patients living with dementia not only face prejudice due to ableism, but also ageism. It has also been shown that caregivers may not be good judges of the quality of life of their loved one with dementia. Caregiver burden often influences the assessment of the caregiver in terms of their patient's quality of life. Finally, there is the risk that allowing advanced directives for patients with dementia could lead to abuse. Patients already can face undue influence to do the right thing and not be a burden to society or their loved ones. I have had multiple patients who have been heartbroken at having been coerced into selling their home and moving into a facility because of family pressures not to be a burden. I cannot currently protect vulnerable elderly from financial abuse with the current safeguards. I do not believe that safeguards could be crafted to adequately protect them from undue influence to accept or request MAID. In summary, I am opposed to advanced directives for MAID as people cannot predict with accuracy how they would feel in a future situation they have not yet experienced. There is no ability to withdraw consent. Even caregivers of those with dementia who know them well have difficulty assessing their quality of life. And finally, these directives may open up another avenue of potential abuse of vulnerable elderly. Thank you very much for listening.
Thank you very much, Dr. Chung. Nous irons maintenant au Dr. Poirier.
We'll now go to Dr. Poirier for 5 minutes.
Dr. Poirier, vous êtes en...
Dr. Poirier, you're on mute. We can't hear you.
Ça devrait être mieux comme ça.
There, that should be better. Yes. Please proceed. You have 5 minutes. Well, thank you to the committee co-chairs and members for the invitation. Good morning to everyone who's listening this morning. I'm very pleased and honored to have been invited to speak with this very important committee. This morning, I'm wearing 3 different hats. First, I'm a researcher specializing in the causes and treatments of Alzheimer's, and I have been doing this for 35 years. I'm also the co-discoverer of the major gene linked to the common form of the disease. I am therefore very familiar with the genetic and environmental risk factors behind Alzheimer's disease, and we can address that in greater depth during the question period, if you wish. Secondly, I'm the child of parents who both had Alzheimer's. I acted as caregiver in both cases, first for my father and then my mother. I went through the usual obstacle course, and I have very direct experience with the way the disease progresses at every step of the way right up to the end. Although I've worked in a psychiatric hospital for many years and I am a psychiatrist, this morning I will be focusing on Alzheimer's. Mental illness is another issue that's very different. Now, what do we know about Alzheimer's in 22? First of all, it's not curable. The main risk factors are genetic and age, and it is impossible to manipulate those through medication. Alzheimer's exists in 2 forms. the young genetic aggressive form, for which we've identified causes, and it's causative. So we know when and how it will strike people. This represents 2 to 3% of all cases. It's not many, but when it does hit a family, it's 1 out of 2 children in each generation that will be afflicted with it. So 8 children, 4 will be sick. The other form of Alzheimer's is sporadic or common Alzheimer's. You've probably experienced or been in touch with someone who has it, and it's considered sporadic. It has a genetic component that represents 60 to 70% of the risk. Now, I'm not talking about causative genes, but genes associated with risk. Unlike the family form, it's not causative genes that are at stake, but risk genes. And this genetic risk must be seen as a combination of risk factors linked to lifestyle, the environment. It includes cardiovascular problems such as high blood pressure, diabetes, uncontrolled cholesterol, obesity, and even uncontrolled sleep problems. So it's a combination of genes and cardiovascular factors, lifestyle factors, that together trigger Alzheimer's disease. So this is something that lasts between 8 to 11 years, and a person loses their capacity, physical and mental capacity. In the worst period, there are deteriorations, and it is things like pneumonia that will kill this patient. Not Alzheimer's, but it will make a person so weak that infections will kill. Over the past 2 years, for example, COVID is what killed people with Alzheimer's in our long-term care facilities. And this brings me to the second part of my presentation, which is an overview of European countries where they have included Alzheimer's as eligible under MAID. In Holland, for example, they found that it was difficult to exercise when it came to mental illness and also with Alzheimer's. In 2018, the Royal Association established very clear guidelines in Holland and reaffirmed a decision by the Supreme Court of the Netherlands, which allows the use of advanced directives within the specific context of Alzheimer's disease. I'll give you some of the figures that surprised me a bit and at the same time reassured me. In 2018, 6,126 patients who requested medical aid assistance in dying in the Netherlands. And of these, 144 made a request while they had a mild to moderate diagnosis of the disease, where it is still possible to make informed judgment or informed consent. So 144 of the over 6,000 applicants were allowed to have medical assistance in dying. And of this group, only 2 had used advanced directives, that is, directives that had been put formally in writing and that their families respected in order to follow through with the wishes of the patient. So there are very few people who used advanced directives with Alzheimer's. In Belgium, it's approximately 4% who sought medical assistance in dying. In Switzerland, about 3% of requests for MAID were associated with mental or behavioral disorders, which includes Alzheimer's. And there they don't make a distinction between those or break the data down. In the United States, there are several problems with dying in dignity. And as we've seen, Alzheimer's makes people vulnerable. It leads to a state of severe physical deterioration, and people are vulnerable to any kind of infection. I'd like to remind you that as part of the debate, we've talked about the psychological pain, that notion. This psychological pain is not only experienced at the time of diagnosis, but is present throughout the disease. especially during the second phase. I'll stop here and I'll, with pleasure, answer any questions you may have. Thank you, Dr. Poirier. We'll now go to Dr. Upshur.
Minutes.
Good morning, honorable chairs and committee members. Thank you for the privilege of appearing before the committee today, and I commend the committee for taking on the formidable tasks that are before them. I'm a professor in the Department of Family and Community Medicine and the Dalla Lana School of Public Health at the University of Toronto, where I'm also the Dalla Lana Chair in Clinical Public Health and Division Head of Clinical Public Health. Additionally, I'm the Associate Director of the Lunenfeld Tannenbaum Research Institute, the Scientific Director of the Bridgepoint Collaboratory for Research and Innovation, and a staff physician at the Hennick Bridgepoint Hospital, Sinai Health, Toronto. I've been in clinical practice for over 30 years with a particular clinical and research interest in the care of older adults. I served on the Royal Society of Canada's expert panel on end-of-life decision-making in 2011, and I was also a member of the working group on the Canadian Council of Academies expert panel working group on advance requests for MAID. I've been past chair of the Royal College of Physicians and Surgeons of Canada's Ethics Committee, and I'm the current chair of the Canadian College of Family Physicians of Canada's Ethics Committee. And from 2006 to 2011, I was the director of the University of Toronto's Joint Centre for Bioethics. The comments made today reflect my views alone and not any of the organizations in which I am employed or provide service for. So I recognize that public opinion polls and survey data indicate strong support for advance requests in medical assistance in dying. However, I wish to raise the following points. As noted, I was member of the CCA working group for advance requests in MAID, and I'd like to commend the CCA and its Chief Executive Officer and President, Dr. Eric Meslin, and the chair of our committee, Dr. Jennifer Gibson, and the members for the exemplary work. It was an illuminating experience. The process was carried out with immense rigor and thoroughness and was as inclusive as possible in soliciting views and collecting and reviewing the evidence. It is, to my knowledge, the most comprehensive examination of the issue in existence, and I do hope members of this committee have read this report with care. As signatory to the report, most of what I think is the case on the topic is in the report. The working group represented the continuum of perspectives on the acceptability of MAID itself, let alone advance requests. There was, however, unanimity in the following points. One, the issues involved in advance requests for MAID are immensely complex. They are of profound importance and significance, and there are large knowledge gaps and uncertainties. I'd like to quote from the concluding section of the report. The main issue with advance directives for MAID is the uncertainty faced by those responsible for following the request when it comes to gauging whether the patient desires assisted death. The responsibility for this decision will fall upon a third party, most likely a family member who has been designated as the proxy or substitute decision maker, not the physician. It's very distinct from the regime that is in place in the Netherlands. If this becomes the case, then it is essential that the knowledge gaps identified in our report be filled as expeditiously as possible in order for there to be an evidence-informed supports for substitute decision makers, clinicians, and others, because the circle of individuals around MAID is quite extensive. However, we must do this recognizing the inadequacy of current support for substitute decision makers and the lack of uptake of advanced directives and advanced care planning in day-to-day practice outside the context of MAID. Much work remains to be done. There is also considerable uncertainty around our understanding of commonly employed concepts such as suffering and extensive clinical uncertainty as to how this is best assessed in even competent populations. So this also raises questions of allocation of resources and whether sufficient resources will be devoted to ensuring the necessary supports for substitute decision makers, clinicians are provided, and that safeguards are in place, that there's a continuous monitoring and evaluation of any regimen put in place for advance requests in medical assistance in dying. The question of whether new resources should be brought to bear on this particular dimension of MAID when we have large extent gaps in end-of-life care is one I cannot answer, but do believe requires close scrutiny and debate. Regardless of how we proceed, tough choices must be made. To paraphrase the 19th century philosopher Georg Hegel, tragedy does not consist in choices between right and wrong, but between two rights. I thank you again for the opportunity to appear before this committee and look forward to answering your questions to the best of my ability. Thank you. Over.
Thank you very much, Dr. Upshur. I will now turn it over to my co-chair, Senator Meji.
Merci, Monsieur le Président. C'est le temps de la...
Well, thank you, Mr. Chair. We'll now move to the question period, and we'll be starting with Mr. Barrett.
I'm co-chair. Thanks to the witnesses for being here today. My first question is for Dr. Chung. You talked about the primary caregivers of patients, and I'm wondering if you can share with us why, in your opinion, primary caregivers of patients living with dementia may not always be the best judge of their loved one's quality of life when they know the most.
So thank you very much for that question, because it does seem counterintuitive that the person that's spending most of their time with that patient would not be the one that necessarily knows them the best. But this has been shown in research. One study that I have I referenced in my original statement submission was a geriatric psychiatry paper where 91 people with mild to moderate dementia were paired with their primary caregivers, most of whom were spouses or lived with the patient. And they were asked to fill out a quality of life survey. So that was the same quality of life questionnaire, both given to the patient plus the caregiver. And because the patient was still mild to moderate, were able to answer questions. There were 5 domains in this. One was self-esteem. How did they feel about themselves as a person? Positive affect, were they mostly happy? Negative affect, did they have anxiety, depression, sadness, guilt? Also, what was their feeling of belonging? Did they feel that they had a part in society, that they feel that they were part of a cadre of people that cared for them? And finally, the sense of aesthetics, which refer to their ability to obtain pleasure in life. And they found that the agreement between the patients filling out the questionnaire and their caregivers was not very good. The other things they looked at was caregiver burden, asking the caregiver how much stress they felt with their job. They also did a survey of how dependent the patients were, and over 50% of the patients needed care, hands-on care at that point. And 44% of them had behavioral issues, so paranoia or some aggressive tendencies. And the thing that correlated the best with a disagreement was caregiver burden. So if the caregiver felt extreme burden in their care, they may have been projecting their feelings onto the quality of life of the patient, whereas the patient may have felt that their quality of life was actually quite good. I hope that answers your question.
Yes, ma'am. Thank you.
Thank
again, to you through the chair. In cases of patients living with dementia, what are the issues in determining capacity to make personal or medical decisions, such as MAID?
So I have not done any capacity assessments for MAID, but I do capacity assessments for finances, personal decision-making, and medical decision-making all the time, because again, a lot of my patients are frail and they are living with issues of potential financial abuse, as well as maybe making decisions that their family doesn't agree with. For instance, wanting to stay at home despite the fact that they're falling, they may not be eating as well, but they really are able to come to a decision and say that this is where they want to be, and their decisions need to be honored. They obviously have short-term memory, so when you're trying to give them the pros and cons, they often have difficulty holding the information in their brain long enough to come with a decision. They have some impairment in judgment and insight, especially if the frontal parts of their brain are affected. They have occasionally emotional lability. So for instance, again, when you have a toddler and your frontal brain is not yet mature, you have these swings of emotions where in one moment you're in the depths of despair and the minute you're laughing and happy, and it can switch quite quickly. Some elderly people, especially with frontal temporal dementia, will have this as a problem, or people have had strokes in the frontal part of their brain. They're also easily fatigued, so a lot of times they cannot have assessment in one go, but you need to have multiple assessments. And finally, they are often completely dependent on their caregiver. So someone is living with them, they're dependent on the caregiver not only for hands-on care, but also for decision-making to help them in life. So this leaves them open to the possibility of undue influence. because you have someone that you are potentially insulting or going to make upset by going against their wishes, you may feel obliged to agree with them. And that's a lot of times what you see in people who tell me they want to live in their own home. They are capable, but because they don't want to make waves, they want to keep their family in, happy, they end up deciding to move into care. And it's legal, they made the decision and they were capable at the time, but it is still very heartbreaking because that is not how they wanted to spend, the end of their life.
Thank you. Thanks very much.
Thank you
ma'am.
very much.
Parfait. Merci beaucoup, Monsieur Barrette. Madame Brie.
Thank you very much, Mr. Barrett. We'll go to Ms. Briere. Well, thank you, Madam Co-Chair, and good morning to the witnesses. Thank you for being with us. My question is for Dr. Poirier. Now, we know that we're in a situation that's evolving. We need to take a position when it comes to independence, vulnerability, among others. You pointed out that both of your parents were diagnosed with Alzheimer's. My mother-in-law is in a long-term care facility. She sleeps 23 out of 24 hours. She's attached to a geriatric chair. Do you think, now you talked a lot about Alzheimer's, but do you think that advanced requests could be used for other issues like dementia in other areas? Answer: yes, well, where we can measure the evolution of a disease, and I will tell you that we do this systematically, the government as well needs to know this. If you need to diagnose, if you're going to be diagnosing medication in BC, it's different, but if you go on the scale below 10, there are scales. So there are ways of quantifying these types of changes and scales to measure it. So my answer is yes. And in order to give you a bit more context, I'm working here at the Prevention Center with some 400 people who are at high risk of having the disease. So the conversation that we're having this morning is something that I've been having with my patients for over 10 years now. These are situations that are very pertinent given your question. Well, how can we monitor consent then? Advanced consent. Now, this would be signed when a person is capable, but how do we ensure that in Quebec that we can ensure that the person has all the information that he or she needs, including the consequences of giving that type of consent? And the second component of my question is, when does this consent take effect? Well, for the when, I always tell children that it's not because someone is diagnosed with Alzheimer's that they're going to lose their car, for example. It doesn't happen right away. It's a decision that's made with the family involved. There's contact with the people who are responsible for the funding, for example, the notary public, the lawyer, etc. And we don't wait to the moderate phase to make those decisions. So it's done when everything is possible, when the person can understand the situation. Now, with respect to when it's activated, there are people who have taken action before us, Holland, Belgium, and the Supreme Court in the Netherlands made a decision in 2021 providing additional clarification. This came from the Royal Society of Doctors with respect to what the ideal situation was. So there's a great deal of experience and expertise there that I would put in place in a more similar fashion here. Now, that it's not about reinventing the wheel in the Canadian situation. Well, as you mentioned, in Belgium, they talk about the time when a person becomes or is no longer conscious of the situation. Now, I'm thinking about my mother-in-law. She is not reached there, but she's always stated throughout her life that she didn't want to live in the conditions that she is now. But we can't do anything. Now, in Quebec, with respect to the Commission on Dying in Dignity, without going in the same direction, well, what do you think would be the solution for implementing these measures? Well, as I said, I come from a research background, and we can quantify the loss of independence. We can easily quantify that with the research tools, and that makes it easier. And we can literally identify a point on a scale of 1 to 5 or 1 to 30 as someone has reached a certain point. And as of that point, the family should be able to step in and activate the wishes of the person. That's my way of looking at the situation and how it should work. Now, that's what I like about the Netherlands approach. With more family involvement, it's not simply all managed by the treaty attending physician. Thank you. We'll now go to Mr. Theriault. You have 5 minutes. Thank you, Madam Co-Chair. Comment inaudible. Dr. Poirier, we've heard from witnesses here, and they've spoken in complex terms, the situation of free choice in an individual facing a neurodegenerative disease like Alzheimer's. And they say, but it's highly complex because we need to make a distinction between dementia and people who are happy in dementia, people who are not. What do you think about that? Now, I assume that this state of being happy is something that's observed. But what happens at that stage? You're a researcher. Well, now I'll be speaking as a caregiver. We said that of my mom. She seemed to be in the moderate to severe phase. She had dementia. She seemed to be happy. She smiled. She didn't cause problems. She wasn't a burden for the health team at the long-term care facility. And she asked me every day to find a way to put an end to her days. Now, look, you have to understand that the brain dies in different segments under Alzheimer's, and it varies from one person to the next. It follows a general pattern, and it evolves differently. But biochemical changes can appear to be changes in the biological makeup of the brain now. With the receptors, for example, that perceive pleasure. And those regions also die in the same way. And so there are chemical imbalances. Now, are those people happy? No. No, they're not, because my mother asked me to do what she wanted. And so there are some biological changes, as I explained earlier, we have no control over. But underestimating the psychological pain, which is often the problem of our healthcare system. We look for physical problems and we step away from the psychological problems, and that's where the shoe pinches. So we have research tools to document that, but happy dementia is a very odd term in my view. Question. Well then, couldn't we go upstream and look at when the decision is made during that meeting between the care team, the patient, at a time when he or she says, here are my wishes? Couldn't we at that point in time then describe that phase, describe that possibility with full knowledge of the situation and clearly ask if the perception of people is that, well, you're in that situation in happy dementia, well, then what do you want us to do? And would a third party not be the solution then? If the third party doesn't say to the care team, well, to do something, then nothing happens. And I assume that it's not someone with bad intentions. We're not going to be making bad decisions in the healthcare system. If it's a third party, then that person has the best interests at heart. And until that decision or that intervention takes place, nothing happens. Well, I agree. I'm sorry, I'm getting a great deal of echo. I don't know if you're hearing a lot of echo as well, but it's a problem for me. Mr. Thériault, please put yourself on mute. So that's what's causing the echo. Well, essentially, now we have the figures that came out of Holland. They astonished me. I was expecting to see the 144 see higher numbers. I thought it would be about 70%, but it was just 2%. And it was the attending physicians and the family that guided the process. But it is specified when advance directives are put in place with the patient who's going to be facing that. And we say, well, how do you want us to react? It's like the situation with my mom. That included not having any oxygen at end of life. There was a nurse from a different culture for whom it was horrifying not to put a tube in her nose, decided to intubate her with oxygen. There was a battle at the hospital to have it removed because there was a union that got involved, but it was complex. But we could see that the interpretation, even by the care team, is different, and it has to be very clear upstream by getting the family involved and the people treating the patient in question. Thank you, Mr. Thériault. We'll now go to Mr. McGregor. You have 5 minutes.
Thank you very much, Madam Co-Chair, and allow me to echo my colleagues in thanking each of our witnesses for offering your perspectives and helping guide our committee through this study. Dr. Chung, I'd like to start with you. I think your opening statement, you've echoed a lot of the concerns that this committee has heard with respect to advance requests and just the idea that your future self may not have the capacity or consent abilities of your younger self, especially as the disease progresses. And we do know that dementia, the word dementia is a scary word for many people. There is a fair amount of stigma attached to it. However, in our last meeting, we had the pleasure and the honor of welcoming a witness by the name of Sandra Demontigny. She is living with early onset aggressive dementia. It's a genetic version. Her father had it. And she is of no illusions as to what the disease is going to be like for her. She was there with her father. She watched his descent into hell, as she put it. And she knows that's going to be her life as well. I guess, how do you react to someone who has such an intimate familiarity with the disease, understands what her condition is going to be like as it progresses, and who very much is expressing her personal autonomy right now for saying, I do not want to end up like my father? How do we wrestle with that as a committee?
I think part of that is I think part of that is recognizing that dementia is different for different people. So, as long as, let me talk as a caregiver as opposed to a physician. My mother was the first female obstetrician gynecologist and first one of Asian descent in British Columbia, faced a lot of racism, a lot of sexism. So she was not she was a firecracker. She was not someone who would sort of sit down and take crap from anybody. And when she became demented, we thought, oh my gosh, this is going to be terrible because she lost so much of her autonomy. She was happy. And, I know we talk about how do you tell if someone is happy if they can't talk anymore. She would sit there with her grandchildren. I'm going to cry, sorry, holding hands. She would sing. Even after she couldn't talk anymore, she would sing. and she passed away at home with my dad by her side. She had a great life. And if I had asked her when she was in her full glory as a physician and a trailblazer, would she have wanted to die like that? She would probably say, hell no. But, at the end, I would say that, yes, she had a good death. She had a dignified death and she had a happy death. And it was really with the support of, everybody at home. So you cannot tell from how you are when you are, like in your 50s or 60s, what it's going to be like in a situation you have not yet experienced. Another paper that I reference a lot of time is they had patients that were going
Dr.
to have...
Chung, sorry
Okay.
to interrupt you. I only
sorry,
have a minute
sorry.
and a half left, but I appreciate
Sure.
your answer, so thank you for
Okay,
that.
thank you so much.
Yeah,
I just get passionate.
No, I totally understand. It's a difficult subject we're dealing with. Dr. Poirier, I'd like to turn to you. The other, we've had other witnesses who've talked about, the need to have clearly defined, objectively accessible criteria included in advance requests. I guess my question to you is, especially after a diagnosis and when the disease is progressing, how often, if advance requests were instituted, how often should those be renewed and reviewed by the patient, the caregivers, and the physician's team in your mind? Do you have any insight that you can share with us?
Oh boy, that's a difficult question. I would say it varies so much. The course of the disease varies so much from one individual to the other. Some people have had a 19-year-long decline, and I've known another one that had 4-year decline. It's very difficult. As I said, there's certain checkpoints that we know of that we could use. They just reach faster in one case versus the other one would be 15 years or 11 years instead of 2 years. But I just couldn't give you a decent answer on that.
That's fine. It's underlying the difficulty of the subject. Thank you, Madam Co-Chair.
Cool. Maintenant, je passe la parole à mon...
We'll now go to my colleague, Mr. Garneau. Well, thank you, Ms. Meji. We have 2 senators here to ask questions.
Senator Wallen, you have 3 minutes. Senator Wallen, this is for you. You have 3 minutes. You're on mute.
I cannot make my headphones work, so I don't know whether you're hearing me.
We do hear you. Please
Okay.
go ahead. We'll see if
Great.
it's acceptable for translation.
Yeah. Okay. So my first question is to Dr. Chung, Ms. Chung. Did I hear you correctly by saying you have no experience with doing MAID assessments? That really your comments here are about
Dementia
your
dementia and medical and personal as well as financial capacity.
Financial capacity.
And medical and personal.
Right,
Decisions
but you
where to
don't
live,
do
et cetera.
MAID.
I don't do
You've
MAID.
never been involved in a MAID assessment. Okay, thank you very much. I'll then go to Dr. Poirier. I want to come back to this question of, and we heard from a witness recently, and this is something from personal experience as well that we can discuss, this concept of happy dementia, which the person experiencing early onset dementia said, this is a symptom like many others. You may feel fear, you may feel anger, you may be violent, you may be happy. These things change literally on a dime. And so for when people declare that that people are happy, it is a judgment from the outside, not from the inside, and it often is there to give the caregivers some sense of comfort that their loved one is happy. But if you spend prolonged periods of time, you will see that that comes and goes like anything else. So how do we get around this idea, which seems to have taken root, that whatever you decided in your 50s or 60s or 70s and 80s about how you would characterize a death with dignity, that somehow all of a sudden you're happy and you no longer want that? How do we deal with that issue that seems to have grabbed hold?
Well, I think you said it right on the spot. It's a judgment call from people around them. I went through that with my mother. Frankly, that was a part of the progression which I did find less painful. But my mother died painfully. She died of thirst. She stopped eating shortly before she died. That's not dignity. And before that, they were force feeding her, and then they used tubes for a while, and that even didn't work. I'm sorry, even if she was on a dopamine spike and felt good about it, she was not dying in dignity. So
go ahead.
No, that's my point.
All right.
I'm not the only one. I'm not the only one.
Sorry, Senator Wallen, the time is up.
Okay.
Senator Miji for 3 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Co-Chair. My first question is for Dr. Poirier.
Vos familles de...
When you're with the families for whom there is a genetic diagnosis and a sporadic one, do you explain it to them the way you explained it to us today? And when you do that, what do you tell them about the future and about medical assistance in dying? What type of questions do they ask you at that point? Well, you met Sandra de Montigny. She was diagnosed when she was young, and her father had it at 41. And she, too, will be at 41 or 42, plus or minus a year. And if the son has the defective gene, it will be the same age. So those people have a ticking time bomb. They know when it will explode. And they are excellent people to speak about Alzheimer's, and she's explained what the situation is, and she can explain to others when the bomb is going to explode, if you will, when that ticking time bomb will go off. And she's working very hard in order to educate people around that. With the common form, it's different because we don't have that timing. We don't know when the ticking time bomb will explode, but we know that it will. But we have tools that will make it possible to determine where things are going based on an evolution of the disease, based on the genetic factor. But there are 75 genes that can be used to identify the risk factor. There are environmental factors. We know how it develops. It's not the same situation as 10 years ago. And we're good at knowing where things are going. Now, what I do with my children who have Alzheimer's, my patients, I say, take into account things that you want to tell your family, what you want to do later. But the only part missing is the issue that we're discussing right now, these advance requests regarding end of life. They can give directives for other areas, and I can guarantee it. I have 400 people that I'm working with on an annual basis, and that's what the educational awareness is. We gave them a way of managing and, to some extent, a way of taking control of the situation. Thank you, Dr. Poirier. I have a second question. Many witnesses have said that we can't predict our quality of life now at the end of dementia. Now, clearly someone can't say it's time to withdraw their request, but people are saying that that's where they have reservations, that the person won't be able to withdraw the advance request. What would you say about that in a few seconds? With respect to the removal of the advanced request? Well, because that person is no longer in a position to do so. There are some parts of the brain that have lost up to 70% of their cells. Some people lose up to 80% of the cells. So those are the brain cells that operate decision making, we can't ask them to make decisions when the brain cells don't exist. That is a scientific reality. Well, thank you, Dr. Poirier. I'd like to give the floor back to, now, if everyone's very disciplined, we started 5 minutes late, we can do a second round if we are all very disciplined. Please start the second round, Senator Mégy. Thank you. Well, for the second round, we'll go to Mr. Ellis. You have 3 minutes.
Well, thank you very much, Chair, and thank you to the witnesses for being here. Very quickly, Dr. Chung, through the Chair, if I might, the study you referenced with respect to patients and caregivers, could you submit that to the committee, please?
Sure, I will.
Thank you. And through you, Chair, to Dr. Chung as well, you talked about teaching capacity assessments to physicians. Can you comment briefly on again, how many physicians might be really good at it, and how many physicians actually are able to perform, in your experience, capacity assessments?
It's really a gradient, because physicians and healthcare workers in general do capacity assessments all the time. When you're giving someone medications or performing surgery, you have to ask permission first. Where it gets complex is when you do have people with mental health issues or cognitive issues which may affect it. And sometimes, even though I've been doing these now for 30 years, there's some people that I cannot say one way or the other. So the default setting is that they are capable unless they can be deemed incapable.
Great, thank you for that.
Yeah.
To Dr. Upshur, you spoke a bit about that physicians should not be the one deciding how to proceed in cases that are, as you mentioned, complex, there's knowledge gaps, and there's uncertainties. I guess that leaves the decision-making to a third party. And how can we ensure then that that there's no coercion or duress? And certainly, even with the physicians on this panel, we've seen that because of their personal involvement with, I think, both their parents, it's become a very, very emotional issue. How do we understand then that that caregivers are to make a decision for a patient without their own feelings being part of that decision making? Obviously, looking after someone with dementia is very, very difficult. It's very emotional. We've seen that today. How do we ensure then that they're not deciding based on their own feelings?
Thank you for the question, and I think I'll echo some of the comments made by Dr. Chung. It's one of the great uncertainties, and I will direct members of the committee back to the CCA report, where we discuss in detail what needs and supports that substitute decision makers and proxy decision makers will need. We will not have a regimen like in the Netherlands, where the physician is the one that makes the assessment of the intolerable suffering and triggers the request for medical assistance in death. In Canada, it would have to come through the substitute decision maker. And as I mentioned in my comments, we have done precious little through time to support substitute decision makers and proxy decision makers in making decisions in day-to-day care, let alone the weighty responsibility that it will be to trigger the initiation of medical assistance in death. So we have a lot of work to do. And like many of the questions here, let's not wring our hands about how complex they are. Let's mobilize research resources and get answers to these questions so that we can not eliminate the uncertainty, but actually close some of those uncertainties. And as a parliamentary committee, I would charge you to direct the CIHR to invest resources in closing these knowledge gaps. They're considerable, they're important, and so long as there's a huge amount of uncertainty, there's going to be hand-wringing and anxiety. And we need not suffer that when we're making decisions about medical assistance in death if we have the means and mechanisms to close those knowledge gaps. Thank you.
Merci. Oops. Is this Monsieur Arsenault?
Mr. Arsenault. Thank you, Madam Co-Chair, and thank you to the witnesses for being here. It's very interesting. Dr. Poirier, I've learned a lot more about Alzheimer's here today. I'm like Dr. Chung. My father has Alzheimer's. I see others. In one case, he couldn't swallow, etc. And I have 3 great aunts and uncles who died in quick succession. Ms. de Montigny, impressed the entire committee when she appeared on Tuesday evening. What an incredible appearance. She has clear, she's clear, she can make decisions about MAID with respect to when the right time is. Now that brings me to you, because you talked about this 1 to 5 scale, this 1 to 30 scale for making a decision. Could you give us some potential solutions as to what we as legislators should consider with respect to when that is? If it's on a scale of 1 to 5, would that be at 0.4? Or if we're talking about 1 to 30, a scale of 1 to 30, would that be at 25? Answer. Well, in research, we have that entire spectrum. Now, as you know, we define the disease between light, moderate, and severe. From a more clinical perspective, we would say 4 or 5 is the moderate, where judgment disappears. So that's a checkpoint. That's an important point where, and based on our experience from Holland, that's a critical time. Now, I work on scales with respect to the loss of memory and judgment. It goes up to 70. So it could be around 55. So these scales exist. Yes, it takes time, money, and an investment, but the situation needs to be defined. It's the level of autonomy and independence and the intrinsic pain. Well, Dr. Poirier, I don't have a lot of time. I've only got 30 seconds left, but what would be the consensus then? I think that's what people are looking for. That's what they'd like to hear. What's the point? Where is the consensus on that? Well, I'm speaking from my personal experience. I can't, but when there is a loss of judgment that is clear and precise, a lack of independence, a significant loss where you're no longer able to be independent, well, that's a sign. Thank you. I've only got 15 seconds left. I don't have any time for extra questions, but thank you very much. And Dr. Poirier, you can send information in to the clerk. She'll be able to share that information on the scales with the rest of us. Please, thank you, and thank you all.
La parole est maintenant à Monsieur Luc.
We'll now go to Mr. Luc Thériault. 2 minutes. Thank you. Yes, Dr. Poirier. Witnesses who appeared before the committee said that we needed to resist opening up MAID because in the development of the disease, the evolution of it, even if someone has given consent as part of an advanced request, when it comes time to administer it, there's resistance, a refusal, or what appears to be a refusal, a rejection. What do you think about that, of that part where there would be some resistance? Well, there's a biological change in the brain that affects all aspects of a person, thoughts, judgment, perception of oneself in space, because the cells in the brain are dying. And we can't compare someone who is at that stage as how they were when they had 20 to 40% more brain cells. It's neurodegenerative, and that's why I didn't want to in my remarks, I didn't want to talk about the other aspect where you Alzheimer's is irremediable. The brain cells die. We scan them and we can see the dead brain cells. We can see them. So should we proceed anyways in that case then? And is there a way of proceeding that would be yes, so that it wouldn't be problematic? Are there ways of doing so, methods? Well, as I was saying, scales exist, the method exists, and after that, it's simply putting in place what the person asked in their advance request. So you're saying it's more of a reflex. Well, I wouldn't describe it that way, but it could be perceived that way. Thank you, Mr. Thériault. We'll now go to Mr. McGregor. You have 2 minutes.
Thank you very much, Madam Co-Chair. Dr. Upshur, I'll turn to you. I don't have a lot of time here, but you did, in a previous answer, talk about our committee making a recommendation to the CIHR to close the knowledge gaps Do you want to expand on that a little bit more, but also maybe broaden your answer to include other recommendations you'd like to see this committee make in its final report to the federal government? Just if you want to take some time to talk about that in the minute and a half that I have left.
Thank you. I appreciate that. So once again, I'll direct the committee back to the CCA report, which very thoroughly outlines almost every aspect of the discussion today and where the uncertainties lie. So where there's uncertainties, a certain amount of uncertainty we just have to live with, but there's a certain amount of uncertainty that can be reduced through, you get the priorities of the questions, and then you fund the research to close those gaps. And I think there's at least 15 different recommendations. I mean, because there's very little known. The scant evidence we have, and I think Professor Poirier has mentioned, is a handful of cases from the Netherlands. And it's not all. We've conditioned a lot about Alzheimer's and certain forms of dementia, but those aren't the only circumstances in which advance requests for MAID will take place. So there is quite a lot. So I would make a recommendation that there be ring-fenced funding, and you can. I sit on one of the Institute Advisory Boards, so there's mechanisms that exist to sort of get funding available to trigger research. Plus, provincial research institutes can provide that funding. I mean, to Professor Poirier's points, he's got scales, but how valid are they? What's the sensitivity, specificity, positive and negative predictive value? Because as we know from living through COVID, testing have thresholds. So here, the mistakes that we make on judging and acting on scales are irrevocable. Right. So there's quite a lot of existential weight to the decisions that are being made. I think a really high priority I would like to make is support for substitute decision makers across the spectrum of care. I mean, Dr. Chung has spoken about caregiving burden, not just for dementias and Alzheimer's, but for any older adult with multiple concurrent conditions. Like we have a crisis in elder care in Canada right now. So so MAID is in advance requests is a small tip of an iceberg of a larger social problem. And we have to ask ourselves and problematize, why is it that people fear dementia so much? Because as everybody's spoken about, they've witnessed things that they find horrifying. But why is it horrifying? Why have we created the conditions where care for dementia is so terrifying? It's something that we created, right? We can rewrite that narrative through investment in care, investment in caregiver support, right? So this kind of fearful negative narrative that I'm hearing about is not necessarily inevitable. There's only a certain amount. I mean, as Professor Poirier said, the brain, it's a neurodegenerative, irreversible condition of Alzheimer's, but we can do an awful lot with social support to make this narrative a lot less despairing than what we've heard. Thank you, and over.
Okay. Merci beaucoup, Dr. Upshur.
Thank you very much, Doctor. I'd like to ask you, if you could, to send the CMA medical report that you mentioned to the clerk. Thank you. And we'll now go back to Mr. Garneau.
A report that was commissioned by the Minister of Justice and Health and the Minister of Health, right? This was a report that was commissioned by the Canadian government to examine the issues of advance requests for medical assistance in dying. It's a 240-page report. You should have it, and you should read it because it covers off all of the issues that we've been talking about today. Over.
So thank you, Dr. Upshur. We do have access to it. With that, I'd like to thank our panelists for this morning, Dr. Chung, Dr. Poirier, and Dr. Upshur. Thank you for bringing your expertise to bear on this very, very important but difficult subject. We appreciate you giving your time to us. With that, we'll suspend very, very briefly. Don't go away, any of the committee members. We're going to start very quickly with our second panel. Thank you.
We have the pleasure of welcoming Dr. Jonah Sebastian Baudry.
Dr. Marcia Sokolowski, who is a psychologist and philosopher, also by video conference, and Dr. Helen Wiebe, medical doctor, also by video conference. We'll get on with it right away. As you know, the procedure is that you will have each 5 minutes to make opening remarks, and that'll be followed by questions. So if you are ready, si vous êtes prêt, le Dr. Baudry, vous avez...
If you're ready, we'll go start with Dr. Baudry. Please proceed. You have 5 minutes.
I just want to express two reservations regarding the legalization of advance directives for medical assistance in dying. My first point is a reminder of the basic legal and moral principle that when people become unable to make decisions, such as financial or healthcare decisions, our law sets up protective regimes to ensure that they do not harm themselves. And an important feature of such regimes is that decisions must be taken in the best interests of the person. They must be taken to foster that person's well-being. We have to provide that person with the care that is most respectful of their residual agency and most beneficial to their well-being. At first sight, it would appear that respecting the instructions that someone gave in the past to treat them in the future looks respectful of their autonomy. However, identity, desires, and needs change over time. So while it may well be the case that respecting past instructions in a way to respect autonomy in many contexts is a way to respect autonomy in many contexts, it's not obvious that it is always the case, especially when people undergo important cognitive changes. When that happens, the person may have experiences and desires that are different from those that they had in the past. For instance, if they never experienced what it is to live a life with less cognitive capacities. To illustrate, let's imagine a 75-year-old patient with dementia called John, who is no longer able to make healthcare decisions. My first point is only that decisions made on his behalf should be made for his benefit. Now, one may assume that, of course, John without dementia, when he was, say, 50 years old, would care about his own future self and know his future self better than anyone, and that would put him in a great position to say what's best for John at 75 years old. But we could suggest that it's not so obvious. For one thing, John may not make a decision in the best interest of his older self. He may have the best interests of someone else in mind. For instance, he might not want to be a burden on an aging spouse or other members of his family. Or he might have his own interests right now in mind rather than the interests of his older, sick self. For example, he might imagine his future self bedridden and highly dependent and feel shame at the thought that this is how he would end his life and this is how the people he cares about would last see him. Now, perhaps this evaluation seems reasonable to many people. However, such an evaluation may potentially share discriminatory beliefs about the quality of life of people with illnesses and disabilities and about whether their lives are worth having at all. Many people live happy lives with various significant medical conditions or a high level of dependency. But if John or anyone within his family or healthcare team doesn't think so because of ableist generalization, John at 75 years old would become the victim of ableist or ageist stereotypes. Now, the point I'm making is that even if you personally believe that John ought to die because you personally would not want to live were you in this situation, we should not end John's life because you feel that way. We should do what is best for John. We should care for the patient before us. And that is John with advanced dementia at age 75. It doesn't mean that John's past preferences are not relevant. The holistic assessment of what is in his best interest may include his past wishes and preferences. So my first point is that giving the last word to the former self of a patient, sometimes a cognitively and experientially distant self, is not necessarily and always respectful and beneficent towards the patient in their current state, especially if a long time passed, if new experiences occurred that the person never experienced before, if new relationships of care and dependency occurred that did not exist before, if new forms of suffering and new forms of resiliency and joy are experienced that weren't experienced before, and if significant cognitive changes occurred in the person, it makes that close connectedness between past and present selves more and more questionable. And so would be a law giving control over the fate of someone with a cognitive disability to a significantly remote past self. Now, if it's true that we must make a new holistic assessment of the patient's needs, not just indiscriminately apply their past wishes, my second point is that it seems very difficult, if not impossible, to detect a kind of suffering that would justify ending a patient's life when patients themselves don't have enough cognitive capacities to express the wish to die. If the state can stay away from endorsing conceptions of lives not worth living, it should. And that second point would apply both to non-voluntary euthanasia and to an advance request law, because for an advance request to be activated, doctors would still need to be able to identify that the patient, John at 75 years old with dementia, has indeed attained the kind of suffering that would justify triggering MAID according to the patient's past instructions. Thank you.
Merci beaucoup, Dr. Baudry. We'll now go to Dr. Sokolowski for 5 minutes.
Thank you very much. First, I wish to extend my gratitude to the chairs and the Joint Committee for the honor of being invited here today to discuss this extremely important topic of the use of advanced directives pertaining to MAID. By way of introduction, I'm the senior ethicist at Baycrest Health Sciences. I have a status-only position as assistant professor in the Department of Medicine, University of Toronto, and I'm a fellow at Ben Gurion University in Israel, as well a member of the MAID House Advisory Council. However, my comments are mine alone, and I am not representing any of these organizations. My comments are also informed by many years of being a clinical psychologist, philosopher, and ethicist within healthcare organizations with much experience with the use of advanced directives with the Alzheimer's dementia population. I have chaired many MAID committees, as well as having provided ethics oversight to ongoing cases. My publications include my doctorate thesis in philosophy on this topic and a book published by Springer International 2018 on the topic of dementia and the use of advanced directives. My academic and clinical experience portrays a range of significant concerns that arise out of use of advanced directives, and I want to say this point with distinction here, at least in the terms of how they are currently being used with the Alzheimer's dementia population. The main question I pose is whether legalizing advance requests for MAID for those who face dementia is morally justifiable. However, this doesn't apply just to situations where MAID is concerned, but equally to situations of where treatments are withdrawn. Later, I will discuss suggestions to alter the conceptualization and use of advanced directives in order to enhance the level and moral justification of their use. As has a number of panelists already discussed, the dominant conception about Alzheimer's is that it's a disease of horrific tragedy and necessarily leads to loss of personhood. At least in North America, this is a very prominent conceptualization. Excuse me. The negative stereotype of Alzheimer's is often at the root of why people write directives in the first place that state their desires to forego treatment if and when dementia does strike. These directives can be especially problematic if the person with dementia is generally happy. We also may not possess the requisite imagination or learned experience necessary to be good predictors of what we may or may not want in future situations when we author our advanced directives. Our values and our beliefs may radically change over time, and our frames of reference may alter. Substitute decision makers, SDMs, might be privileging also particular kinds of interests over others and not necessarily the patient's interests over others. SDMs do not always follow even relatively clearly expressed treatment wishes for a variety of reasons, as my research has shown. It's problematic, therefore, to assume that having a substitute decision maker to interpret the directive and provide the requisite informed consent generally adds any merit at all. There is potentially tremendous subjectivity, variation, and inconsistency occurring with regard to conceptualization of the advanced directive in the first place, how its contents get interpreted, its intended and actual use, and how and if it gets applied. I also learned in my work that it would be a mistake to assume that the author of the directive behaves in a more predictable fashion. It would not be exceptional for him or her to neither expect nor even want the directive to be perceived as definitive. Rarely, however, are these expectations or wishes known to the substitute decision maker. And even if they were, they would not necessarily prove to be the current expectations or wishes of the person with dementia. To increase the moral nature of advance directives, not only should these concerns be rectified to the point possible, but authors of advance directives ought to be educated about the downfalls as well as the strengths of having an advance directive in order to be better informed when making a decision about whether or not an advance directive is in their best clinical interests in the long run. I have some clinical and policy recommendations. One, an advance directive ought to be explicitly considered as only one piece of information amongst many about a person's intentions and or preferences. It is not the sole determinant of settling any medical treatment decisions. Two, because an advance directive document is at best a weak example of the principle of autonomy, treatment wishes in any advance directive should not be construed as equivalent to or having the same self-determination status as treatment wishes made in real time by the patient. Three, many people with dementia will be capable still of holding values, wishes, and interests that matter to them. On this view, they ought to be considered to be at least borderline or partially autonomous, and medical treatment decisions should be made that cohere with them whenever possible. For a directive that's very recent and doesn't seem to have been made obsolete by changes in the patient's statements or attitudes or responses to treatment, can be treated simply as a current expression of their wishes. Then, in some imprecise but significant way, its status as a current expression, hence to be taken as an exercise of autonomy currently, degrades quickly with the passage of time or the onset of attitudes or behavior, i.e., let's say general happiness, in tension with the content or presuppositions of the advance directive. In terms of...
Doctor, I'm going to have to ask you to wrap up. You're past your time.
Thank you very much.
Thank you. We'll now go to Dr. Helen Wiebe for 5 minutes. Dr. Wiebe, you're on mute.
That's better. Thank you so much for allowing me to talk about a subject that I've thought so much about, talked so much about, and am so interested in. So my experience is in assessing almost 800 Canadians for medical assistance in dying and providing for over half of those. And I was a family doctor for over 30 years and so saw lots of dementia patients at that point. And I'm a researcher and have done a lot of research on MAID, including on advance requests. So I'm going to focus the first part of my talk on the paper that I sent you. And I just want to make a few highlights about this. First of all, the majority of Canadians want advance requests. Now, a number of other researchers have found this. In our study, we asked about specific situations, as in, would you want to be able to have an advanced request if in particular situations, and 86% of our participants wanted it. So, we're going to have advanced requests. If we don't get it in 2023, we'll get it the next year, or we'll get it with the next parliament, but we'll get it because we live in a democracy and 86% of Canadians want it. So what is it? What are these specific things? In our study, we talked about is loss of personal dignity, including being unable to toilet, loss of freedom, like being kept in a locked facility, loss of the ability to recognize family members, loss of ability to keep memories even for a few minutes, loss of the ability to control behavior, as in becoming aggressive and inappropriate. Now, the second really important finding of our paper was to see a gap, a gap between what the people wanted and what MAID providers were willing to provide. And this gap, depending on all these different specific situations, varied between 19 and 44%. So just because you make an amendment to our law doesn't mean that you'll be able to have an advanced request that is acted upon. So we worked hard as a research team to look at what would make it work. And we, of course, asked the MAID providers in our study and discussed. So what helped most would be a list of very specific circumstances that were concrete in nature, readily visible to practitioners, to family members, to caregivers, stable. In dementia, it's very common for people to have, for example, sundowning, where they are fine in the morning and they're not fine in the afternoon. And that this would require minimal interpretive judgment by the provider. We have no experience in advanced directives, but we have experience in waivers of final consent. And we are finding that, first of all, patients love them. They are so grateful when they find out that they don't have to worry about losing capacity before the date that they've chosen for MAID. They are so relieved. And I know this is going to happen when we get our advanced requests. The other thing is that the providers actually didn't have any problem providing in the people who did lose. But as in my case, I mean, I have signed many waivers of final consent. I've only used them twice, and in both cases it was just so clear. But this was different because I knew these people, I had assessed them, I had seen or talked to them recently, and that's not the same as meeting somebody that you've never seen before in a state of advanced dementia when you have to interpret everything. But what we are used to doing, and this comes to what you've just heard from the others, is taking each case separately and looking at the entire picture. So I would want to see somebody who not only wrote their advanced directives, but had told others in the process of advancing disease that they wanted it. And then the question about suffering, yeah, it's a big problem. If I saw some lovely demented old lady who was playing with her dolls and looked perfectly happy, would I be able to end their lives? I don't think so. No matter what she had said in the past. So you're stuck. I mean, all you can do as a parliamentary committee is recommend an amendment to the law, and the law has got to have the word specific in it so that it is clear that an advanced request is not a general one. It must be very specific, and that each case has to be assessed separately, which is exactly what we do for every MAID case when we are looking at the entire life of a patient, not just a few specific criteria. And thank you.
Thank you, Dr. Wiebe. Je vais passer la parole à la sénatrice.
I'll give the floor to Senator Wiebe for questions.
Merci, Monsieur le Président.
Well, thank you, Mr. Co-Chair. We'll start with Mr. Ellis. You have 5 minutes.
Well, thank you very much, Madam Chair, and thank you to the witnesses for appearing. First of all, if I might, through Chair to Dr. Beaudry, you talked a little bit about protection of peoples and against self-harm, etc. One of the things that came up in one of our earlier panels was some research around the concept of suffering and how difficult that is to detect. Could you speak a bit about that, please?
Sure. Thank you for the question. Well, I think a key issue is that suffering is highly subjective. It's not an objective benchmark. Severe pain can be more medically objective, but suffering is not. So without the patient's input, it's simply a myth that we will not make a value-laden judgment about which life is worth living or not. Consider in the province of Quebec, Quebec's Bill 38, which proposes to amend Quebec's Act respecting end-of-life care to include advance directives. It says that the advance request must describe in detail the physical or psychological suffering that cannot be relieved in a way that the patient would find tolerable when they write the request. Then a monitoring system would be put in place so that when the patient shows sign of that suffering, the MAID process can be started. Now, the problem is that, to come back to my example that I gave before, if John at age 50 is able to consent and explain that he's experiencing an intolerable suffering such that the death would be preferable in his mind, that's it. Doctors, judges, legislators don't have to ask the absolutely unsolvable existential question of what is a life worth continuing. They just need to respect the fact that John made his own existential choice that no, it is not worth living. But the notion of intolerable suffering cannot just be transposed onto someone who cannot make this choice, including John at age 75 and with advanced dementia, and that is because suffering is a complex subjective experience. We can measure pain, we can treat pain. Ultimately, we can eliminate pain completely if nothing else works through deep sedation. But we're not talking about a response to pain. MAID has been designed and is used primarily as a response to existential suffering, such as the loss of ability to engage in meaningful activities or the loss of ability to perform activities of daily living or other fears that have to do with hygiene. Bill 38 in Quebec says that there is a special kind of suffering, that special kind of suffering justifies MAID or euthanasia, and patients can list that specific type of suffering on their advance request. Now, the point I'm making is that I'm not clear on what that suffering is, nor is the Quebec Bar, which produced a memorandum last summer stating that suffering is a subjective notion, not an objective standard. And the Quebec Bar's working group on MAID said that they were wondering what Bill 38 meant by this, I quote, objectifiable kind of suffering that is observable by a doctor, like doctors observe the symptoms of physiological dysfunctions and diseases. Presumably, it means something like objective or objectively verifiable. But subjectively intolerable suffering that is worse than continuing one's existence does not seem to be objectively verifiable. There's nothing objectively verifiable about the intensely personal leap that someone takes above that abyss of disagreements about the value of life when they move from experiencing specific social and physical issues on the one hand to the decision.
Dr. Baudry, I'd like to interrupt you there. I have about a minute left. Thank you for that. I appreciate it. To Dr. Sokolowski, through the chair, you talked, I think, about the substitute decision maker not having merit in this particular process. And to me, correct me if I'm wrong, but to me, the difficulty now we're coming to is a patient who has no capacity to make decisions on their own. Who's going to decide, a physician or a substitute decision maker? That becomes very, very difficult. We have about 30 seconds. Thank you.
Yeah. I think substitute decision makers can indeed have a lot of merit. I think what's problematic is often they don't, because they're not up to date in terms of what the patient has expressed in a written or oral directive. And I think that advanced care planning is a better way to go, because with advanced care planning, at least the wishes and values of the patient are updated, so to speak, on a pretty regular basis, so that the substitute decision maker can really understand what are the values, the attitudes, the beliefs, and the specific, requirements, wishes that the person has.
Merci, Dr. Sokolowski. Merci, Monsieur Ellis.
Thank you, Doctor. Thank you, Mr. Ellis. We'll now go to Dr. Fry. You have 5 minutes.
Thank you very much, Chair. This is such a very difficult issue. And here we are talking about the legality, talking about what lawyers think, talking about what caregivers think, talking about what family feels and what families think. And at the end of the day, this is all about that individual person who may or may not be trapped, as we heard from Dr. Poirier, in a place where they are no longer able to make the kind of decisions, where so many of their brain cells have died that they are trapped in a space. I think we need to stop using legal language and using a whole bunch of lingo for what in effect is a subjective and very important decision. I was very moved by Dr. Poirier's testimony when he basically said that his mother begged him when she was lucid at the very rare times that she didn't want to continue. But yet she had caregivers whose own culture and morality said that she was happy and she should continue because she was being made comfortable by them. That is a very sad, very. I mean, I could imagine what she must, in her lucid moments, have been thinking. I think we need to look at what the advanced requests and advanced directives have a certain importance. When the person is cognitive and able to make decisions, I think they tell us what their morality is, what their own sense of self is. We learn things from them. And as Ellen said, Dr. Weeb, said, you know the patient over the long term, you know who they are. And so when they get to a point where they're unable to make the kinds of decisions that they would have made, you know what that person believed in, what their morality were, what their values were, what they were thinking, how they valued certain things. And making that decision needs to be made on an ongoing long-term basis. Families, I mean, this is a question. I'm not making a speech, but I'm saying the conundrum that all of us face. And to say that we can make a clear legal statement that's going to make a decision generically for everybody doesn't make any sense. This is not a generic issue. It's based on the individual person and what you know about them before they moved into the area where they are no longer in need, or people are making decisions for them with regard to advanced directives. I think we need to start going back to what the Supreme Court originally said, which is this is about the subjective decision-making of an individual person.
Excusez-moi une minute, Dr. Frey. Pouvez-vous réajuster?
Dr. Frey, could you adjust your microphone slightly, please? It's causing some... Move it up slightly.
Oh, if it is. Yep, is it? Okay, thank you. So what I'm
s'il vous plaît, je m'excuse. Un peu plus haut encore.
Just a little bit more, please. It's picking up your breath for the interpreters.
Merci.
Yes?
It is better, yes, thank you.
Yes? Okay. All right. I'm making this kind of statement because I do think that we are thinking as clinicians, we are thinking as family, we're thinking as lawyers about all of these things, and we're not thinking of what is that person in the lucid moments, few lucid moments. We may not even be able to talk to them in those lucid moments when they definitely say, I don't want to be here anymore, or I do want to be here. I do want to continue. We have a really difficult problem. And I think if we try to parse this into legal constructs and into families who want their mom with them for a longer period of time and go, look, oh, mom looks happy. She's playing with dolls and isn't she great? These are the kinds of things we don't want to make sure that the government of Canada or the people of Canada decide for an individual human being what their end of life should be like and what their choices are. I don't have an answer. We're asking you guys to come and tell us because we're hoping one of you would give us an aha moment. But at the end of the day, I don't know that it is all about us. I know that it is about that person, that individual, specific person. And so, we heard from Dr. Poirier, we heard from Dr. Chang's
Je m'excuse,
daughter.
Dr. Frey. La question, s'il vous plaît.
I'm sorry, Dr. Frey. Your question?
Dr. Maggie, I am just trying to tell you that I am still not sure of what I'm hearing from everyone. I'm trying to weigh everything that everybody's saying, but other than a person who is going through this and has lucid moments and can come and tell us, please do not judge me from the outside or from all of the other things, legal and other, that you believe in. Let me tell you what I originally, when I knew who I was, wanted. That essential me may not have changed inside. My brain cells may have gone, but that essential me is still there. Respect that essential me. That's all I wanted to say. I am finding this a very difficult decision panel. I am finding this whole issue extremely difficult to think about because we are all deciding for people.
Your time is up. The next person on the list is Mr. Thériault. You have 5 minutes. When it comes to decisions as sensitive and intimate as our own death, it seems to me that the government's role is not to make a decision in our place, because the state or government isn't the one that's going to die in the place of the person, nor the neighbor. The role is to ensure that free choice exists. The problem that we currently have is because the right determines life. Why would this not apply at end of life? Why would we be going beyond this principle of self-determination, which is entrenched in law? No one can give themselves the right to determine the quality of life by comparing it to the quality of life of someone else. So that's another principle. It comes to the person himself or herself to make the ultimate decision with respect to quality of life. Now, Sandra de Montigny said, I'm going to shorten my life if you as legislators do not allow it. And this is the spirit of Carter. It's the spirit of Baudouin. The right to life is being violated because people are having to shorten their life instead of living as long as they can. Now, I don't know anyone with a disease who doesn't want to live as long as they can. So what they're asking for from us as citizens is for help, for guarantees that the day that I get up, for example, having gone beyond my tolerance threshold, you'll help me to go. And it seems to me that that is acceptable. And it's up to us to do that because we can't violate the person's right to autonomy and self-determination. Those are the principles that guide my way of understanding the debate today that's before us. And what's painful in the debate that we're having, is that a person may lose their capacity in a degenerative state to give a final direction. This was removed in C7 at the terminal phase of life, and it was clear. So I don't understand why the last wishes of a person aren't being respected. What we need to do, us, is to put in place the best conditions for exercising the carrying out of these wishes. And in that regard, Dr. Wiebe, what should we do to ensure that that willingness, that will is respected, and that the doubts that we see emerging today be removed from the equation?
Thank you. Yes, what you can't ensure. That's what I was trying to say. It's not possible. You need to recommend an amendment to the law that allows for advance requests, because that's what Canadians want. They really want it, and most of them want it, because there is such terrible suffering at the end of life that can be prevented, and that some of us are horrified by. But you will not be able to actually ensure, because we have limited MAID providers. We don't have enough for our track 1, which is the natural death being reasonably foreseeable. We don't have nearly enough for the track 2, which are the natural death not being reasonably foreseeable. And come March, we won't have enough for the mental illness as a sole underlying condition. And we won't have enough for the people who need to be, the advance directive needs to be acted. But to do the best we can for the most people, just to say that first, the person must be very specific, and even specific about things like, if I'm happily playing with my dolls, I do not want to continue that sort of life. And then you have to leave it to the clinicians, as you do now, where we have to take it case by case. And in these kind of cases, I will look at what the person wrote. I will try to find out what was their aims in life in general. You know, were they the kind of person who told their kids 20 years ago that they never wanted to live in a demented state? Did they, were they part of this? Was this part of their whole being? And that will make it easier for me to be able to provide. So you're never going to be able to fix this problem completely, but you can do what's best for the most people.
Thank you. We'll now go to Mr. McGregor.
Thank you very much, Madam Co-Chair. Thank you, Madam Co-Chair, and thank you to our witnesses. It's been pretty remarkable, I think, for our committee listening to the wide range of subjective experiences with dementia, either from clinical practice, from personal familial relationships of other people who have gone through the disease, and sometimes it's been both. We've had clinicians who are experts with dementia who have a close family member living with it. And Dr. Wiebe, I'd like to start with you because, you were talking in your opening statement about the research that you've done and, surveying people's attitudes and support for advance requests and some of the reasons that were behind that. You mentioned a fear of the loss of dignity, the loss of freedom, loss of memory, the inability to recognize close personal familial relationships. And certainly the theme of stigma with dementia has been common for this committee. I know that just saying the word dementia for many people conjures up a lot of negative emotions. And I'm just wondering, in your research, did you dig down to, when people were expressing their thoughts about dementia and their support for advance requests, did your research uncover any currents about, what's informing people's attitudes towards dementia? Because some people may not have a very good knowledge of the disease, but others have incredibly close relationships, and they've been informed by that. Do you have any other thoughts to share on that theme?
Well, the people who went into detail about why tended to be the ones who said, I watched my mother, I watched my aunt. And so they know a great deal about dementia from the outside or inside a family, but outside the person. And so they were very knowledgeable. I think the people who have no knowledge of personal knowledge of dementia are less likely to be interested in the subject and want to talk about it.
Yes, panel, the first hour of today's meeting, Dr. Upshur was talking about, he was referencing the state of end-of-life care in Canada, and that may also be something that informs people's opinions on dementia. And he said that a lot more research and resources are needed in that. Do you have anything to add to that?
So these are the kind of conversations I have every day with my patients. And they talk about, if I can't take care of myself in my own home, I don't want to live any longer. They talk about independence, not just quality of care, but having strangers wipe your bum. That's such a common statement. And, you know, people can say, we have really good care in our home. Yeah, but you still have somebody else, you know, changing the diapers. And so that is what people will talk about in terms of what is just unacceptable, that there is no care level acceptable for that level of disability, because that level of disability is unacceptable.
You referenced that democratic pressure that exists. You know, there's a very strong majority of Canadians who support moving ahead with advance requests. So that democratic pressure exists for our national parliament. And you also mentioned the word, you know, if we are going to amend the criminal code, you mentioned the word specificity. Like, how much specificity do we attach as federal legislators, and how much needs to be left to the provinces? How do those work together?
Right.
Yeah.
Okay. Well, I'm not a constitutional expert or political one. So I know that the criminal law can't be as specific. Just make sure that the word specify is in there somewhere, so that a advanced directive that just says, kill me if I'm a vegetable is not legal. Like, it has to be specific. And then we'll have smart people figuring out the best ways to write those specifications.
Okay, thank you.
Parfait. Merci beaucoup, M. McGregor. Je passe la parole à M. Garneau.
Thank you, Mr. McGregor. We'll now go to Mr. Garneau.
Merci, Madame Mégy. Alors, on va
Thank you, Senator. We'll be wrapping up our panel with questions from senators.
Senator Wallin. Senator Wallin, you'll have 3 minutes.
Thank you very much. I just want to comment on what Mr. Beaudry said about advance requests that we might make at 60 would maybe make no sense to us at 75 or 80. I just have to say that we do this all of the time within the law and legally in this country. We write wills. We leave them with lawyers, and they may have been written 5 years ago or 10 years ago or 20 years ago. We have DNR, do not resuscitate orders. We now have final waivers of consent. You know, there are lots of concepts around where this is practiced. The legislation that I'm putting forward in the Senate now has been based on consultations with people who have been part of this process for a very long time. We are proposing that there be a long list, and to Dr. Weeb's point, very specific circumstances where a person doesn't want to live and wants to proceed with their advanced request. Not that, I can't feed myself on Tuesday, but very specifically, I am no longer able to feed myself on a consistent basis. It goes on through all of the things that she's already noted. The other part that I think is very key to this is that the updates of this need to be regular. We've said 5 years. I'd be very comfortable with 3. And I think we have to do what gives the most people comfort on that question. And then we come to this very important role of the substitute decision makers. They can't just show up 5 minutes before this request. These people also have to be involved in the process of making sure that this is updated. This is a huge commitment for people, but I think it's the only way we can do it, that if you are going to be one of my 2 substitute decision makers, you are going to have to participate in this process of updating, being interviewed by perhaps a lawyer or a doctor or a medical professional in this field, because the issue is, when it comes to the provision of MAID, it may not be your family doctor. That may not be the person. So these substitute decision makers need to be very, very familiar with your wishes over a long period of time. I can't think of any more safeguards that we can put in while still respecting the person's views laid out repeatedly about what constitutes quality of life and dignity in death. Dr. Wiebe, do you have anything else to add to that list that I should have been considering?
No, that sounds good. As I said, it has to be specific enough that you'll find a provider who will actually provide at that point.
Yes, I
Thank
realize that that's
you,
an
Doctor.
issue for
Thank
everyone.
you, Senator Wallin. Sorry, 3 minutes goes by very quickly. Sénatrice Mégy, à vous la parole pour 3 minutes.
Senator Mégy, go ahead. You have the floor for 3 minutes. My question is for Mr. Baudry. You expressed 2 reservations earlier. In light of that, in order to remedy the situation, would you have some suggestions or a suggestion, an additional safeguard, if you will, for advanced requests?
Dr. Baudry?
Dr. Baudry?
Parfait.
Yes, thank you. Can you hear me? Yeah, thank you for the question. I'm going to continue in English if you don't mind.
So in terms of specific solutions, I have not yet reflected in depth on that very difficult issue here. But what I do, where I do see my own research going, and where people I think would benefit from looking at, is the distinction that's been drawn, for instance, by the Council of Canadian Academies between the different scenarios. That is, of advance requests made when the patient is already eligible for MAID, advance requests made after the diagnosis but before MAID eligibility, and advance requests made before any diagnosis. Because for sure, the last case would be the one where my argument would apply most strongly, where the continuity between previous wishes and current wishes are no longer there, so that really there it would ring some alarm bells to many people within the disability community, I gather, to hear how dignity is correlated to wearing a diaper or receiving help with hygiene care, and how we can stipulate, because many arguments that I've just heard right now, and I find them so interesting, many arguments that I heard right now would open the door to respecting people's autonomy. But that's my whole point. It's not the same person in meaningful ways. If it's very recent, it's a different issue. If it's distant, we don't give anyone the power in Canadian society, not even if everybody agrees democratically or anything else, to make life and death judgments on the basis of potentially ableist or ageist judgments about someone who we should care for whom protective regimes are usually in our law set up to work to protect the person. Considering, of course, their residual autonomy, of course, their past autonomy. But if we consider their past autonomy as encompassing something as specific as when I'm not able to do X, where that assessment would never fly, if we're thinking about the welfare of someone and we're trying to think of a well-being so dismal that it calls for death, which is such an intensely personal choice that requires an ability to consent, it's a bit puzzling. But I've written on this myself in the case of non-voluntary euthanasia, and I think some of it applied to this case. I'm happy to forward because it's such a philosophically dense topic. I'm not able to do it justice here, but I'm happy to forward it to the committee. But I haven't. Yeah. Thank you.
Thank you, Dr. Baudry. I'm afraid time is our enemy here, and we are at the end of the panel. But let me thank d'abord le Dr. Baudry. Merci beaucoup.
Thank you very much, Dr. Baudry.
Sokolowski and Dr. Wiebe, thank you for giving of your time today. And I think in the case of Dr. Wiebe, very early in the morning. I believe you're probably out in British Columbia. So thank you very much. We appreciate your candor and your passionate views on this very difficult subject. With that, this panel comes to a close, and this meeting is now adjourned. Thank you.